10 petitions. The CJ says no prima facie. What is prima facie? Simply that when you look at the thing on the face of it, there is a question to answer. The CJ has done what many say is an elevation of the threshold of finding prima facie. He says that while the allegations against the Electoral Commission bosses, Jean Mensah and the two others, Bosman Asare and Samuel Tete, while the allegations raise serious constitutional and administrative questions, they do not, on their face, meet the threshold required for a prima facie determination of stated misbehavior or incompetence, warranting that a committee be set up to inquire into the petitions. So there were 7 against the Electoral Commission heads and 3 against Kisi Ejabing. So far, 2 petitions under Nana Akufo-Addo against Kisi Ejabing, one by Martin Amidu, one by Ken Koranche. The 2 failed. Looks like we forget about those. They failed. There was a petition for the removal of the Chief Justice, Gertrude Tokonu. That also failed. They didn't make prima facie. So 7 for the removal of Jean Mensah and her colleagues. They have also failed. Let me find out from this table if they demonstrate what we see on the streets. There are some who are celebrating, and there are some who are angry. Minister of Seni.
Yeah, so there are some who are celebrating and justifiable so. And there are some who are disappointed because they think that particularly the EC, they think that the EC should have gone for further investigations. And if investigations have proven that they were otherwise not guilty of incompetence or stated misbehavior, then the Chief Justice could come to that conclusion. But to dismiss it on the face of the petitions, that none of the 7 petitions raised a prima facie case against the Electoral Commission is worrying, especially if you put it against earlier thresholds, and that is the concern. But I think that I have a feeling that we are now dealing with a Chief Justice who is an institutionalist against those who held people occupying those positions liable for errors in the. He wants to
explain that.
No, so I think that the Chief Justice, from my reading of what he's said about particularly the Electoral Commission, admitting that there were serious constitutional and administrative breaches, okay? But in his view, on the face of it, does not warrant the finding.
He didn't say breaches, questions.
Questions. He said
serious constitutional and administrative questions.
Okay.
But they do not, on their face, and prima facie is on the face.
Yeah.
They do not, on their face, meet the threshold required for a prima facie determination.
So that clearly, so he acknowledges that there could be questions. So that's why I said, I would have said that, well, if I were Chief Justice, I'm not. I would have said, well, because of the serious constitutional and administrative questions, on the face of it, I've seen that. So you have to come to try to explain.
He doesn't stop there. He says that the petition largely rests on conclusions of unlawfulness and bad faith without establishing at a preliminary level. They didn't establish at a preliminary level. Clear facts demonstrating intentional wrongdoing or a manifest inability to perform constitutional functions.
So if there is a constitutional question which manifests itself in the form of a breach, does intention matter? If the Electoral Commissioner feels, neglects, or refuses to file his properties with the Auditor General, does his intention to file at a later date matter? Does it matter? It's a question, it's a constitutional question. And in your view, it's a breach. And that breach must have consequences. So that's how I see it. That's how I see it. And then he introduced another thing that clearly puts us on a journey to discovery. Because he says, in his view, it does not meet the threshold. What's the threshold?
He says you are talking about conclusions of unlawfulness and bad faith without establishing at the very face, preliminary level, clear facts that demonstrate intentional wrongdoing or a manifest inability to perform constitutional functions.
Yeah, so
even if the commission's actions or inactions are assumed to be erroneous, controversial, or suboptimal, such shortcomings do not automatically translate into stated misbehavior or incompetence within the constitutional sense.
So I'm looking at it in terms of incompetence, particularly with SAL. Mm-hmm. So what clear facts do you need for SAL? The people exist. They are by law to be represented in Parliament. An election was conducted. These people were not represented in Parliament. Their inability to be represented in Parliament is because the Electoral Commission failed to create a constituency.
That's the question. Is that the fact?
That's the fact.
Okay.
It's a fact.
Electoral Commission failed to create.
To create.
Willingly.
No, I'm not bringing, I'm not qualified. I'm not
That's
qualified.
The question he's asking you.
So I'm not qualified.
Were they intervening facts? Were they court situations? Were they Parliament's job?
I'm not looking at the facts. Mm-hmm. So I'm not looking at the subjective. That is, why didn't they do it? I'm looking at the objective. I see a people. The Constitution says that every person in Ghana has to be represented. And that's why we divided the country into constituencies. And I see, as a matter of fact, a manifestation of an inability by a commission to get people to be represented. I also see from the Constitution, Article 97 or so, that the representation is taken seriously by the constitutional drafters, that if you are an MP and you fail to be in Parliament for 21 certain days, you have no excuse before the Privileges Committee, your seat will be declared vacant. I see that too. So I take representation from the reading of the Constitution very seriously. And I see these people were not represented. And so I see it. They're facts. I see it. I don't know whether it was intentional or it was inadvertence or it was just by operation of circumstances beyond their control. I don't know that. But I know the facts are this. So I expected when if I put in a petition to say that these people were incompetent, and you see that they were constitutional and administrative questions on the face of the petition, the least I expected was to tell them to come and like the Ashanti say, oh, you know, to come and tell me, to come and tell the committee, come tell us exactly what happened. That Centrophy, Akpafo, Lolobi, and Likwe were not part of Parliament. If they come and they discharge that responsibility, I say, well, we cannot, that was not incompetence on their part. But if I say that on the face of it, what facts again do I need to establish on the face of it? And that's why I'm saying that the only reason why I say that the decision is a decision that seeks to establish institutions of governance is I see Bafo Bone as an institutionalist. From this judge, finding, I see him more directed towards creating powerful governance institutions for this country and making sure that people who occupy those institutions are not subjected to the whims and caprices of other Ghanaians to make them very unstable. That's how I see it. But there are serious issues with it. Now, the second issue I have with it is consistency is a virtue in jurisprudence. And that's why we have precedent. Never mind that he didn't set the first precedent. But it's a precedent in our electoral practice and constitutional practice. That once upon a time, breaches of an act of parliament, the Procurement Act of Parliament, was held to be enough to meet the threshold of Article 146(1) of the Constitution. Incompetence. Now, today, by the judgment of, or by the decision of Justice Bafubone, it appears to me that that threshold was a lower threshold. And probably, if Justice Bafubone were sitting at that time as a Chief Justice, Charlotte Osei would not have gone home. Because again, institutionally, we would have protected that institution. And particularly when the threshold, his threshold, is not breaches of statute. Okay? But there must be higher. And then you come to...
He's entitled, is he not?
He's entitled to that.
In making the prima facie,
yes,
to take a threshold that he finds ought to be the proper threshold and not following any precedent. Because in the Charlotte Osei kind of precedent,
yes,
we were all told that that precedent was so low.
Yes.
Well, I led Kokubako to the court to challenge that decision on the basis that she did not take one CD and chop. You are accusing of procurement breaches. There's a way to resolve that. The processes are there. It doesn't question her competence. It doesn't bring about infirmity by, inability to perform the office. When you read the CJ's decision, he clearly shows you that you have raised issues. They raise questions, serious questions.
Agree.
But they don't bother on incompetence of the officers. They don't bother on intentional wrongdoing. So I will not vindicate that on the face of it. Take SAL. The EC issued a statement to show us how they were not liable for the SAL situation. How the local government ministry directive is what led to the SAL situation. How Parliament is the entity that endorsed the situation that led to SAL not having representation at the time. So how do you say they should take the fall for it?
I'm not saying they should take the fall for it. I'm not saying that.
You said the CJ should follow precedent.
I'm saying, no, I'm not. I said, no, let me recount what I said. I said, from the decision of the Chief Justice on the 7 petitions presented to him for the removal, referred to him by the President for the removal of the Chief Justice, he appears to have set the bar very high. And that when you compare that bar set by him against that set for Charlotte Osei in similar circumstances, it seems the Charlotte Osei bar or threshold was low.
Okay.
That's what I've said. I'm not saying they should have taken it.
All right.
I'm saying that, and I said, for consistency's sake, when you make a decision that departs from an earlier decision, one is obliged by reason of your legal analysis to try to justify what would have occasioned a departure.
The prima facie you are suggesting is a judicial decision, but it's an administrative decision. So nobody is bound to follow the other.
No, I'm not
this is not a Supreme Court decision where you have to explain why you are departing.
I'm not saying that he's bound by the prima facie, but his decision,
should explain.
His decision compels me to try to see why he's departed from that prima facie.
So it does look like you are not even allowed to say he has departed, because the way Sofia Akufo thinks, it's not the way he thinks. And the two of them were not sitting in a court. and not sitting in a court means that nobody owes anybody an explanation why I don't follow this person's own or this person's decision.
So prima facie decisions are administrative, fine. But they are also constitutional. They are founded in law.
Right.
The Constitution requires it. Now, prima facie decisions are decisions that ought to be taken by certain relevant bodies under the Constitution. And so when a prima facie decision is taken, we think and we believe, as people who practice the Constitution, that you must be able to see some consistency in terms of, that is exactly what we mean by the rule of law, that things, persons equally circumstanced will be treated equally. Now, so when they depart, we now are forced to re-examine why a prima facie decision in this case is different from an earlier prima facie decision. And I agree entirely with you. By our training, the idiosyncrasies of the judge and not any pretensions is what we call the law.
Right.
Well, what he sees here, and what Bafo sees in this matter is the law. And so it's finished. There's no application for it. There can't be a review of his decision. There can't be an appeal against his decision. It's finished. There can only be an entertainment of fresh petitions, but there cannot be an appeal. So it's finished. That's the law. As to the seven...
It may be questioned. Like Justice Tokonu is questioning the prima facie on the case.
You go to court and question
it may be questioned.
It may be okay, so you go to court and question.
Yeah.
On basis on which he has come. But you can't review it. That's his decision. He's come to it. But I'm not really against the decision.
Okay.
To the extent that I see him as an institutionalist.
The NDC is not happy because Sedun Ketia said the people should go. Other members of the party all said they are not fit for purpose. They should go. They are the ones who are angry now.
Yes, but he didn't see prima facie. And he sees that we need to build that institution. On that score, I agree with him.
He sees emotions and all sorts of things that don't matter when you are dealing with the law.
I don't see emotion. I don't see that we are using emotion. I see that he himself has contributed to the confusion, in the sense that he said that on the face of the petitions presented, there are administrative and constitutional questions. But he is now importing intentionality as one of the conditions which must be met.
Maybe you should also ask, where do administrative and constitutional questions get answers?
They get answers in a petition.
In a petition?
Yes.
Okay.
In the petition. So when the petition is submitted and there are these issues raised on constitutional and administrative matters, you refer so you ask for them to explain, and when they explain and you are not satisfied, you refer the matter to a committee, you set up a committee, and let them come and tell the committee that, well, there has been gross misinformation on our role in this matter. Because what has happened was actually a doctrine, to some extent, doctrine of necessity, that this situation had to come about because of other intervening institutions which failed to do their work. We don't know. We just know that the Constitution says that the electoral commissions shall create constituencies, and everybody ought to be represented in Parliament. So that's the first thing. The second thing is, then you come to Charlotte say, I also agree that he didn't take the decision, Charlotte say. And again, the idiosyncrasies of the Council of States is the law. And those idiosyncrasies of the Council of State cannot be...
In taking the decision on Tokonu.
Okay. Cannot be attributed to him. I also agree with that. But when you read his opinion on whether or not the petitions raised prima facie against the breaches that were said to have occasioned the finding of prima facie in the Tokonu case, you cannot fail but come to the conclusion that the bar also was lower there.
Simplicity.
So the NPP and those who have been arguing all this while that the bar was lowered in Gertrude Tokonu's case are right.
No, I'm not saying they are right. I'm just saying that, so we are looking at, you see, you must understand, that is why we want consistency. Yeah. That's why we want consistency. And that's what, and like I said, that's what the rule of law is all about. Now, So you find that in the justice...
What is this consistency you're talking about? Because look, I'm asking you this question.
So if we don't, in the absence of consistency,
yes,
let's say that we must hasten as a country.
Because not everybody agreed with what found prima facie in Charlotte Osei. Not everybody agreed with what constituted prima facie in Gertrude Tokono. So where is the consistency?
So
there's no consistency doesn't come in.
It's the lack of regulations. Because he introduces another word, threshold. Mm-hmm. Where's the threshold? Whose threshold?
He's clear. He says that as far as he is concerned, if the issue you are raising, you can't show on the preliminary level clear facts of intentional wrongdoing or manifest inability to perform constitutional functions. Article 146 is not about doing just anything, but incompetence, inability to perform your functions because of ill health and what comes with it. Maybe you are sick in the head.
I ask myself, to be honest, the question that we should all be, that should agitate our mind is, in a breach of the Constitution, or in an alleged breach of the Constitution, do you need an intention? A function has been entrusted to you to perform by the Constitution and you fail, refuse, or neglect to perform the Constitution. Do we need to know why what was your intention? What motivated you to refuse or neglect to perform that function?
Is there a clear, he says, clear, manifest or demonstrable facts
and I say
that there has been inability to perform a constitutional function?
Yes.
If you take Sal, is there? Who says so?
Well, I say so. I say so because
you are ignoring the facts.
I know Sal, I know Santrophi, yes. I know Aquafo, I know Lulubi, I know Lipe. They exist. These are facts. I know that by the Constitution, they ought to have been represented in Parliament. It's a fact.
Yes.
The Constitution guarantees them that.
And who's doing it?
And I know that is going to find the wrongdoing, the person who did the wrong.
But that's what you must punish the one who did the wrong.
But the Constitution doesn't name anybody for the creation of constituencies than Electoral Commission.
What is the Parliament's role?
What is Parliament's role?
But Parliament is the one who endorses what has to be. EC cannot sit down and create and it will come into being.
No, so EC creates and then lays the CI in Parliament. And the CI takes a 21-day journey.
And parliamentarians sit down and watch. Is that what you're saying? That's their job?
So we don't watch. If you want me to give you further and better particulars. I was in Parliament in 2020 when the EC came, the chairperson of the EC came and addressed the members of Parliament in a committee sitting. And the former MP for Ho, the late, what's her name? I've forgotten her name. She got up and drew the attention of the EC to the fact that Santrophi, Akpafo, Lolobi, and Lipe were not part of any constituency in Ghana. And I was there. EC did not apply to withdraw, to amend, and let it pass. So you see intentionally, okay, I don't want to use intentionality because I see a breach. And that breach has consequences. And persons who engage in that breach must also suffer consequences. That's how I see it.
That instrument, that legislative instrument, establishing the Gwa district, which is Sal, as in Santro, Kofi, Akpafo, Lolobi, and Lipe areas. It was enacted on the 9th of November 2020. That date coincided with the day Parliament went into recess. And they were not returning until December 14, 2020. Which meant that after the scheduled dates, the general elections were coming on the 7th of December 2020. You are saying that Parliament decided that what? EC has brought something Yes. So we don't check.
No,
we won't check anything.
We checked everything.
We'll let
the minority
pass.
checked everything. That time, my good brother.
So why was it not? Was the why minority was it? It was not even raised. Right?
It was raised.
Let alone to shoot it down.
It was raised. You can't shoot down the a CI just by a simple majority. You must shoot it down by a 2/3 majority. So that is the first thing. You can't shoot it down. So by 2/3 majority. And when a CI is laid in Parliament, it makes the 21-day journey. I mean, it becomes law, unless it is withdrawn.
All right.
What you will do is that when the commissioner came to Parliament to brief Parliament on what they were doing to ensure that the elections was conducted in the way that will manifest the outcome that the people desired, her attention was drawn to the fact that the Santrofi, Akwafo, and Lobi, Likwe were not part. She failed, refused, or neglected to do anything about it. That is very, I mean, for me, these are the facts. And I thought that if she had any, and again, you say that the CIA, the district was created.
I need to understand you in something briefly before I move on, because I've spent some time with you. I need to understand you. You say you endorse the CJ's approach
in terms of the
principle of institutionalism. You endorse the CJ's approach.
The principle of institutionalism.
And yet you are still thinking that he should have found prima facie, which would have negated what you endorse.
No. So if he found that, then what you are now raising would have been subject to investigation.
Can there not be investigation of any matter concerning EC, OSP without a recourse to, a removal?
So that removal process, the petitions calling for the removal of the EC and her deputies was founded on the fact that certain things were done by the EC which ought not to have been done, which in the view of the petitioners were breaches of the Constitution. It is not that the person wanted to hold the EC accountable in the way that made her stay in office, but remediate what she had done. No. So if EC wanted, Justice Bafo-Boni wanted, or in his view, the threshold for removing an EC electoral commissioner or commissioners was not met. All he had to do, in my view, was to say, well, I've seen these constitutional questions. And he admitted that they were constitutional questions. And so I think the prima facie case has been determined. Go and still an institutionalist, if the commission or the committee was set up and they looked into the matter and saw that, well, this occurred by no fault of the electoral commissioners. So
let me read this quickly to you, then I'll move on to my other guest. Master Planner Junior Kintampo, policy analyst, he says that the EC cannot be charged for the issue of SAL because it wasn't its fault or EC officers' fault. Constituencies are created by EC, but districts or municipalities are not created by the EC.
Yes.
According to our laws, before a constituency is created, a district must first be created. In the case of SAL, there wasn't any district or municipality for a constituency to be created by the EC. How can the EC be blamed for that? The law is the law.
Well, where is he getting this?
I was asking you this question.
Where is he getting this? From which law?
I was asking you this question. That Imani, who have been on the necks of the EC about these matters,
yes,
Franklin Kujo,
yes,
applauded the CJ's decision. That, including other governance people who have applauded this decision.
That what?
That this is progressive, that the judiciary has now been unshackled. That's the word he used.
Oh, but that is, I'm not arguing differently.
I'm saying that the people who complain are praising the decision.
I'm not arguing differently. They say they are unshackled in the sense that you have a Chief Justice who appears to be looking at the broader picture of protecting institutions. That's what they are saying. That's what Imani is saying. Okay, so we're not arguing differently.
Okay.
Except that Bryce Simmons was one of those who took the EC to court on sale.
That's the point I'm saying.
So he wasn't louding.
Franklin Kujo, not Bryson.
Franklin Kujo.
Yeah.
He was not louding.
On their side.
Yes,
in the court.
He was not louding the Electoral Commission for failing to perform their duty. But he's saying that, well, I think that, one, the threshold established by the Bafubone appears progressive because it will provide some security for occupants of office. Okay. That's how I
Boama, Manche Bruce says, Chief Justice Bafuboni's dismissal of the petitions to remove the EC chair and special prosecutor is indeed refreshing. And this is a comment that you would hear from various governance people. It appears he's keen to leave a lasting legacy. What's intriguing is how his stance differs from the grounds that establish a prima facie case for the removal of former Chief Justice and others. Amazing convictions. I didn't ask you about the Special Prosecutor 3.
Other friends, you know my position on Special Prosecutor. You know my position. I've watched the Special Prosecutor, and I think that the petitions, I mean the dismissal of the petition, unless there are grievous matters which can be founded on Section 15 of the Special Prosecutors Act, the Special Prosecutor cannot be removed that way.
These are frivolous.
I don't think that. I think the bar is right for the.
There's a last one though by Martin Pebu that is pending.
Let it come. Even with the EC, I don't think that the 7 petitions will be the last.
There'll be some more.
There'll be some more.
That's why HQC Prempers Committee have put in their recommendations that if people take up frivolous petitions, they should suffer for it. There should be punishment for it. Because people cannot just be throwing frivolous petitions. So that, take the OSP. For how many years? 4 years. He's been fighting how many? 6 petitions. And this is a toll, instead of focusing on the work. 5
petitions. 2 under Nana Akufo-Addo, 3 under John Dramani Mahama so far. But what we
Pebu's own are to make it 6.
It has been delivered already. I don't know that.
No, the decision has not been made, but that makes it 6. What I mean is that he'll be working on that instead of working on doing the job, catching the corrupt people.
It's unfortunate. But my position on the OSP is that we should let him do his work unless there are grievous things that he's doing that infringe Section 15. And so far, I don't see anything wrong.
So you don't expect the CJ to determine Pebu's petition?
I've not seen Martin Pebu's. I've heard Martin Pebu talk passionately about his petition, but I've not had the benefit of seeing his petition. And I don't want to see his petition because, again, let's give fidelity to the Constitution. All these matters are supposed to be in camera.
Okay. Yes, Boama.
Samson, I think the outcome of Chief Justice response to this petition or decision
10 petitions
only vindicates the position that we've held long ago regarding the former Chief Justice Gertrude Sabatu-Konu, that her removal was way below the standard you expect for a person of that high level of a Chief Justice removal.
What does it do to the Charlotte Osei and her colleagues?
Yes, I'm coming there.
Okay.
Because you see, these petitions, the Electoral Commissioner, the status of the EC is equivalent to a Court of Appeal Justice.
Correct.
Same as even the Special Prosecutor. They sit at equivalence to Court of Appeal. And then you have a Chief Justice who sits at the Supreme Court. So if you want to remove people of even equivalence to Court of Appeal, and you get a standard like what the current Chief Justice is introducing, then you wonder, in the instance of Gertrude Tokonu, what really had gone into that conclusion that a prima facie was established.
It makes me ask the question immediately. Do you also wonder what went into the decision that led to Charlotte Osei and her two deputies suffering?
I'm coming there. I told you I'm coming there. Particularly, when in the case of Gertrude Tokonu, we all don't have an idea what's happening at the Council of State level. But at least the former Chief Justice who sits at the Council of State, Sofa Akufo, raised concerns and actually said she disagreed with that establishment.
She has been questioned. That if you are talking about people who lowered the bar, she lowered the bar on Charlotte Osei, so she doesn't have the moral right to speak.
So if at the end of the day, you have chief justices to take that decision, okay, she had the benefit of taking a decision on Charlotte Osei. And even there, we had issues and concerns. I said, and I agree on all falls. The issue is not about EC because ECY. EC is a constitutionally established body, independent body, which ought to be protected against some of these things because it goes to the core of our democratic governance. And so when you have institutions like these, and then you receive petitions, and you have the benefit of establishing prima facie, it is for no reason that that burden is put on either the Council of State or the Chief Justice to establish it. Because by the time that you establish it, you should be convinced without any equivocation of doubt that there is really a matter that ought to lead to satisfy the conditions under Article 146, that the person had done that to show that the person is incompetent or the person has those things. So I think this outcome by the Chief Justice questions where we have taken this whole issue as to petitions, removal of the Chief Justice, and that which we are being faced today, and even to also send a signal that in future, if people are presenting petitions, because see why? The issues that are being raised, you talked about, they are constitutional issues. Yeah. And if they are constitutional issues, there are forum for you to deal with those issues. That forum is not a petition for a removal of a person in office. If you have constitutional issues, you should take them to the proper forum. You don't hide behind it and put that burden on the head of that institution. But we sat in this country and we've seen this happen in Charlotte Osei's instance. And then we saw it even worsened in the case of the Chief Justice, Gertrude Tokonu, and we played politics with it. We thought it was being done whether for a purpose, and if the purpose, and that's why he puts these things in some challenges, because the NDC had made that categorical statement that they will remove the Chief Justice and they will remove...
Made it where?
Oh.
Oh,
it was, you can just Google from my joy, you hear all of this.
Okay, so we have fact-checked that.
Yeah.
President Mahama, who you attribute this to, never spoke in respect of Gertrude Tokonu, removing her. Right.
No.
He said in reference of who?
No, didn't remove the no. Because it was part of our manifesto.
When the issue was going, we're debating it here over and again. He never did.
No.
But Buama, how do you look at this coincidence? It just, came to my mind.
Yes.
Gertrude Tokonu did prima facie determinations.
Yes.
And exonerated the special prosecutor
Yes.
twice.
Yes.
So she would have done
And the
a
Council of
higher
State,
threshold.
The Council of State did it for her and exonerated her.
Yes. And this is the CJ that you guys didn't want to participate in anything he had to do. And he's sort of upholding the Gertrude Tokonu standard.
No, but what do you expect? You see, the issue is not... No, the issue is not about the competence of the Chief Justice. The concerns were to stay his appointment till the issue of Gertrude Tokonu was exhausted.
Okay.
So we have no issue at all with the competence of Justice Bafuboni. That has never been our position. The position was that the basis for removing Gertrude Tokonu was problematic. She had the right to challenge it. And why? Samson, do you have a copy of the establishment of prima facie from the Council of State concerning Gertrude Tokonu?
No.
I'll be interested in seeing what formed the basis of establishing that prima facie against. Let's get that off.
But in law,
Yes.
that establishment can be one line sentence.
Yes, it can. But I believe there's more. They will try to do a thorough work to support that establishment, and for transparency, good governance, accountability. So we all know that these issues ought to be properly situated
for fairness,
so that in future, yes, because the Chief Justice Gertrude Tokonu has suffered a lot in terms of her own reputation, reputational damages. And so we need to be very mindful and guided that, yes, in the case of the ECY, even if they have established a prima facie, should have the opportunity to go and defend themselves. Yes. But in establishing that prima facie is what we've always called for, a standard. And he asked, what's the threshold?
What's the threshold?
If the threshold is not even defined, yes, the Constitutional Review Committee is looking at it. They've said they are going to...
They've done it.
Yes, exactly.
But it's been said that bad people will make a good constitution bad. But good people may make a bad constitution good. So isn't that the case? If you read, and I've taken my time to read over and again, you know, His Lordship's decision. And I find that you can see that his view is that, and because I've had the opportunity to do these cases before, I've done once, I've done twice, I can see that he's taking it from a place where he says, the Constitution says, it must border on incompetence. If it is not about your job and how you deliver on the job, incompetence, forget it. It must border on what do you call it? Infirmity.
Yes.
Either you have a mental situation or you are just ill, you can't perform the job. And he looks at it and says, manifestly, there's nothing like that.
In the case of Gertrude Tokonu, where she's being accused of traveling with their spouse and children and causing some financial burden on the judicial service, does that constitute incompetence? Does that constitute? So these are the facts that are guiding our position.
All right.
No, it constitutes incompetence. It constitutes misbehavior. Except that, so let's put it in better perspective. What Gertrude Tokonu did is misbehavior, is incompetence. But,
Counsel.
No, listen. But the introduction of the, if you want, the confession and avoidance clause, provision in the opinion of Bafobone, they say that we can see that there are constitutional and administrative questions. You understand?
Of course.
Constitutional and administrative questions. Now, and says that, well, those constitutional and administrative questions, because they are not further clarified or manifested by intentionality or a lack of ability to perform, they don't meet the threshold of declaring them prima facie. So that's a constitutional matter. In the Gertrude case, it's not a constitutional matter. It's an administrative matter. And if you want a breach of a statute or guidelines, you understand? So when you put that one,
okay, let Boama finish. But I suppose you know where I belong. But in this case, I'm asking the questions because where I belong is where I led Kukubaku to the Supreme Court.
I also belong
to say
there.
That it's not every sin that must lead to the ultimate punishment.
Yes.
Exactly.
Otherwise, no one, all of these people, even the president, they won't survive.
Exactly. So
how about the OSP 1, 2, 3 petitions?
The OSP one, I think, of course, issues have been raised about his performance. From Parliament, I've had cause to question not just the office, because I agree with the establishment of the office of the Special Prosecutor, but in terms of the resources that have been given to him and then the deliverables, I don't think he's been up to standard. And so for that, we've raised those concerns.
That's debatable, you know.
No, so that is not incompetence.
No.
That's performance.
No, so I'm saying that that has been my issue, and that of many others in terms of his performance.
Performance.
But in terms of those petitions seeking to remove him. I don't think the
So what you are saying is that I give you $1 million, and you are expecting that the $1 million would deliver, 100 convictions.
Yes.
And he hasn't brought 100 convictions.
Yes.
That is not incompetence.
No.
That is not inability to perform.
No.
And therefore it cannot stick.
Exactly.
So you agree with the CEO?
Yeah.
Okay. Yes, Hadia.
Okay, so I want to be the Santo of the day. And still stand by Ghana first. You see, these issues, I always don't want to base it on NDC MPP, because UP is the order of the day.
United Plus.
United First Ghana Party. The youth of Ghana and the people of Ghana are realizing that NDC MPP will always take sides when it's favoring them. Premier Fashe doesn't mean that they cannot go through other processes to come back. They can bring their evidences. What the CJ said is that there are no forms of incompetence.
On the face.
From where I sit and from what you read, it was clear. Even the EC, people on the platforms are still defending. If our Parliament House sat and watched that certain districts and communities in Ghana here who also have the right to bring presidents in power were not given their constitutional rights. We should be fighting about how to bring these people on board so that they can vote for United Party. You see, so that is my worry now. I am fighting for the individual Ghanaian whose voice cannot be heard. So let's fight on working hard to help the EC put these people on board so that they can vote. That is the most important. Ghana first. United Party. Let's leave NDC and people behind and bring United Party into power so that we can fight and settle these issues. When it comes to the OSP,
the SAR, do we remember that court cases were even lost? So the judges too, did they think there's prima facie? They thought there's no prima facie. Well, have you thought about it that way? It just occurred to me that the SAR issues were questioned in court.
That's a conversation for another day.
Unsuccessfully. Okay, Adia, go on. Go on.
So when it comes to the OSP, I always say that when I sit down, I think about how we are going to move forward and get answers. It's not about the talks. The talks are, we want action. We want to see things happen. We want to see people being prosecuted. We want to get the things back, retrieve. So I always sit and imagine that if there has been one case that has been fairly, should I use the word fairly?
Yeah.
Treated. And we've gotten some huge sums of money back as Ghanaians, we will be proud of the system. We will be proud as Ghanaians of the OSP's office. So we want accountability, fairness from OSP. If I had my own power, I will also petition
the OSP to do it.
The OSP to be accountable.
He's
to
accountable.
Be on his feet. We should come after.
So you see what you're talking about.
Yes.
You know, when you get into a judge's mind and they have to do a job, even when they are doing a quasi-judicial but administrative, you see your emotions, they don't matter.
Emotions.
They look at what the facts say. Like Boama talks about how much they have received, you talk about how much they have received and what output. When they put the facts there, they too say that you are wrong because you are not paying attention, because you have done more than you think should have been done. And the judge will look at both and say, No prima facie. That's going on. That's what is going on.
Yes.
The reverend who led one of the petitions for the OSP, you know, he spoke to me. He was very angry. You know, he wants to do a demonstration, and I asked him to what end, you know.
Yes, but when we are behind, we can give pressure, as we are doing. We want to see results. We want accountability as Ghanaian youth. If we have been able to retrieve some money, can't we sort the teachers out? We will be able to pay salaries. We'll be able to subsidize these cocoa issues.
But that's not incompetence. That's not inability to perform the functions of the office due to infirmity. That's the constitutional threshold that the CJ is talking about.
Anyway,
but Samson, can we also look at the effect? You know, when the Chief Justice was removed, the way it tied into our anti-corruption fight, how we are handling institutions of state. And so is it the position that if we use some of these bases to remove independent constitutional bodies, it also have international ramifications or effect to the extent that we're using politics to weaken institutions of state?
No, I disagree with you.
No.
Because what Bafubone has done has established John Dramani Mahama firmly as a believer in the rule of law. Firmly. That if he receives petitions, he will deal with the petitions in accordance with the Constitution.
He's bound.
That is bound.
Yes,
and
he's bound.
And
he's bound. And all presidents have done same.
I am really proud about the
people do not see an overt or covert intention of the president or action of the president to influence an outcome.
But the challenge is,
so in
the instance of the Council of State, is it possible that the composition of the Council of State could have also played a role and an influence in reaching that conclusion?
Could we also argue that
you said they are bound to forward them, but they don't always forward them.
They don't always forward them.
Presidents receive the petitions, and some of them they sit on it. They just trash them.
What I'm saying is that
it is only in the OSP law that subsequently you made a law and put timelines there. The president receives it within 7 days. He must forward. Within this number of days, the decision must be made. Within 90 days, the whole panel must come to an end.
Take advantage of the OSP law. That's why sometimes when people are talking about it, I said they know the industry that entered it. But the fact is that the argument you are making, the composition of the Council of State, that argument could well go for Bafubone.
Okay. So because we are running out of time, the Red Alert Interpol has deleted it permanently against Ken Ofori-Atta. As we understand, he was supposed to have been in court on was it Thursday or Friday yesterday? Yeah. It doesn't look like that's happened, but he's still in custody. That appears to be the situation until when he appears in April, is it 21, for the hearing that must go on. Is there any impact on the ongoing process for him?
Samson.
In a minute, yeah.
Samson, the Interpol red alert notice, to all intents and purposes, is spent. It's a spent distance. So its removal has no effect whatsoever, real or perceived, on what is now happening in the case of...
What was the use? What was the use?
Was it necessary?
No, it was necessary because it was imposed, it was imposed to restrict his movement. Because he could be lost to the state.
Did he do that?
Yes. He was traveling up, in and out. And when the Interpol red alert notice was imposed, he was confined to a single place in the United States.
But he had always been the United States.
He was moving. He was traveling. And so that is the first thing.
So that's what disabled him from traveling to another country to go back to the US to avoid his visa expiring. Okay.
That's the first thing. Then that's what prevented him from expediting his application to change his status
No, but
You understand?
whatever,
Let's say in 30
yeah, but
seconds. Our
whatever
time is
it
up.
is, the conclusion by Interpol is that that particular decision to put him on red alert was not correct, was improper. It was grounded in political vendetta. And so whether the presence of the...
Did they say political vendetta? They said something. It's not political vendetta.
Oh, it was the politics. Yes,
political vendetta.
So
but
was
do you find
with politics.
why they said there was politics around it? Did you find a reason?
Oh, but we've always known. I have
No, it was
find a
not
reason.
the arrest
It was not the
and
arrest.
the processes. It was the commentaries on the back of it, particularly from the Attorney General's department.
And the deputy, yeah.
But
Because the first time
that has been the position that
the first time Ofori-Atta challenged the Interpol red alert notice, he didn't challenge it on the basis of politics.
Okay.
He challenged it on the basis of wrong procurement of the arrest warrant.
Yeah.
All right. So I'm sorry, but my producers say that my time is up and I should sign off. Thank you very much. My outfit is by Habil Scooter. You can call them 0200 84 1988. 0200 84 1988. My guests have been Hajia Gloria Amenu, National Women's Organizer of the United Party. Inus Ofori-Atta is former MP at Tamale Central and former Minister. Isaac Boama Nyako is lawyer, MP Efia. I'm Samson Ladia, and have a good afternoon.